Our show it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, let's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property, Leo, okay? Suddenly Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, good morning, everybody, and welcome to the show. Today, we're talking about the top 10 pitfalls of seller finance investing. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like our channel. You can find us on YouTube, Facebook, and you can find us on X, formerly known as Twitter. At each of those, you can find us at the handle @InRem Podcast. That's @InRem Podcast. Also, go and download an audio version of the podcast. Doesn't cost you anything. You can subscribe on Spotify or Apple Podcasts. Just download it. You can do yard work while you're listening to the podcast. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So my legal update today is answering a question that I receive quite often, which is, why use an LLC to own investment real estate? Meaning, why can't I just put it into my family trust or in my personal name? You know, why should, if I have investment real estate, why should I put it into a limited liability company, also known as an LLC? And basically, the answer is twofold. So first thing to remember is you want to create a separation between your personal assets and your business assets. So your personal assets would be, for example, generally your home, where you live, your furnishings in that home, your clothes, your vehicles generally, but anything that you own personally, and that is what you use to engage in your personal affairs. And then you have your business side of your life. And your business is, what you use to generate wealth or income. And so, for example, investment real estate would be the business side. And you want to create a separation between your personal and business. And the way you create that separation is you put your business assets, which would be real estate that is held for investment purposes, you put that asset into a limited liability company. And then you operate that limited liability company like you would a business. And that then creates what we call a corporate veil of protection. So it basically creates a wall between your personal finances and your business finances, or your business property. And by creating that wall, you are then protecting your personal assets from any creditors or fallout related to your business investments or your real estate investments. So what I mean by that is, let's say you have a long-term hold piece of real estate, you have tenants in there, and God forbid, either one of your tenants or somebody they have onto the property somehow manages to electrocute themselves on the property, and they're seriously injured or killed. Well, that's a fairly large personal injury claim. That's a pretty large lawsuit that could be filed against whoever owns the property if they can establish that you knew or should have known about the issue with the electrical that caused the person to be electrocuted. And if you don't have enough insurance to protect against that, then there's a high probability you're going to end up with a judgment against, or the owner of the real estate is going to have a judgment against them. Well, if you hold the real estate in your family trust or in your personal name, then that judgment is against basically you personally, and the plaintiff's attorney and the injured, party or their family can then go after your personal assets to recover the amount of that judgment. And so they can go after your bank account, potentially your real estate, depending on the homestead protections. They can go after your wages. If you work a W-2 job, they can go after your wages. They basically can wreak havoc within your personal financial life if you hold that investment real estate in either your family trust or your personal name. However, if you hold it in an LLC, then in that case, the judgment is against the LLC. And if the only thing that the LLC owns is that piece of real estate, it would not be a great thing to have that piece of real estate be lost. But that's the only thing that's basically on the hook, is that investment real estate. And you're then protected personally from any other issues. Now, once again, I mentioned insurance. Nothing that attorneys can do from an asset protection standpoint can take the place of good insurance. So definitely work with your insurance agent, make sure you're, fully insured, properly insured, protected from an insurance standpoint. But for the rare case that there's going to be a judgment that's going to exceed the insurance coverage available, at least you have an LLC form so that the judgment is only against the LLC. Now, the second reason why you want to create that separation is for any creditors of you personally. So we'll use an accident scenario again. You're out driving your vehicle, going to the market to pick up milk, and you accidentally run a stop sign. And God forbid there's somebody in the crosswalk and you hit them and you seriously injure or kill them. It's going to be a multi-million-dollar claim at that point. It may exceed your insurance coverage. And if it does, then the judgment will be entered against you personally. And yes, they can wreak havoc with your personal financial affairs. But guess what? If the investment real estate is in an LLC, they cannot then take that judgment and attach it to that LLC so long as you've been properly operating that LLC like a business and keep it, corporate formalities and basically keeping that veil of protection in place. They cannot then go and put a lien on that piece of real estate because the judgment is against you personally. It's not against the LLC. So it's very important from an asset protection standpoint to make sure that if you are going to own real estate that you hold for investment purposes, that you put that real estate in the name of a limited liability company so that you can have that corporate veil of protection and create that, wall between your personal affairs, financial affairs, and your business affairs.
All right, Sean, thank you for the legal update. With that, let's get into a couple brief announcements. It is Tuesday, so in addition to our show, every Tuesday at 2 p.m. Arizona time, we host the Creative Finance Collective. What is that? Well, if you're new to the show, what the Creative Finance Collective is, it's really a group of professionals, mainly lawyers in the space of creative finance. What we do is we get together, we talk about what we're seeing with respect to creative financing, sub-2 type deals in each of our states. So we talk about what's happening with the law in those respective states, problems we might see that clients are running into, and talk about ways that we can make each other's forms better. But the main reason that we host this live is for you, the listener. What we do is make ourselves captive and available to you for the entirety of an hour. So if you've got questions, this is your opportunity to ask them. And we'll answer them as best we can. Oftentimes there are questions that, you might be coming and approaching this from a state that, we're not lawyers in, and we're going to refer you to or suggest that you talk with a lawyer in your state. Nothing replaces that, but this is an opportunity for all of us to talk about the risks, the benefits, pitfalls, so on and so forth of creative financing, and for you to hear that from the perspective of attorneys in the space. And trust me, in the space of creative finance, there's not a lot of attorneys out there. We struggle to find folks that we can refer out in different states. But if you've have an interest in that, make sure to join us every Tuesday at 2:00 p.m. Arizona time. And you can get that on YouTube. You can get that on Facebook or on X. Make sure to join us. Also, For today's episode, we're talking about seller finance and seller financing investing and the pitfalls associated with that. If you have questions about that, make sure to post those in the chat. We'll try to get to those in the final 15 minutes of the episode. Don't wait until then. You'll forget about your questions. Post them now. We're monitoring those, and we'll get to those as they come up. As I mentioned, today we're talking about pitfalls. So specifically, we wanted to address the top 10 pitfalls for seller finance investing. And with us to discuss that is Mark Monroe, real estate investor out of Florida. Mark, how you doing?
Wonderful. Thank you, gentlemen, for having me again. I appreciate it.
Yes.
Doing great. Just got back. Little jet lag. I was overseas and for the holiday weekend. So beautiful.
Exciting.
Yes.
So did you have to fly far? Because we're just talking about a holiday weekend, not 10 days.
Yeah, I was in oh my God. What's the island off of Spain where Rafi Nadal's from? Oh my God, I'm having a brain fart. So it was about out of Newark, it was about 8.5 hours, and then from there to Florida it was about 3 hours. So I was up yesterday morning. What was it? 12:30 Eastern Standard. So what would that be, like 10:30 your time coming back? So it was a long day, but it was beautiful. You know, it's just magical over there.
You're gracious to be on after all the jet lag. We really appreciate it. So Mark, you've been on our show before, and some folks know you, and I know you've got a really big Facebook group, so a lot of folks on the East Coast and Florida know who Mark Monroe is. But why don't you give our listeners a little bit of a background to how you got into real estate investing?
Well, first of all, thank you guys for sharing. We share the collective in the group because I think it's really it's very important that people understand what's going on in regulations so people are informed. So thank you guys for sharing that. The more information that we can give out there, the better it is, so people can kind of learn from it. But a little bit about my background is I'm going to show my age here. I started in 1995 at the age of 24. Doing real estate banking up in the Washington, D.C. area. I ended up having a real estate banking lending firm with 107 loan officers back in the day. So what happened was a lot of my clients who were investors I became friends with, and we started doing all these creative different seller financing strategies back in the 90s. I mean, these strategies have been around for a long time. Over the years, people come up with different terminologies for different things. You know, nowadays they call them a wrap. Back then, we used to call them sandwiches, but it's all the same concept, the same things, just different things change over the years because, you get a couple bad apples out there doing certain things. So regulations come down the pipe, which, you guys see what's going on in Texas right now. We'll talk a little bit about that. But anyways, that's my background. I've done easily about $450 million of real estate transactions over the years. And I enjoy it, and I love it, especially you can do it remotely anywhere in the world nowadays.
Now, Mark, you've even written a book about this. Tell us a little bit about that.
I did. It's called, actually, I wrote it 2 years ago. What happened was my other half's father was sick. So we're out in Palm Springs taking care of him. And everybody kept asking me, hey, why don't you write a book? So I finally wrote a book. It's called Creative Real Estate Investing. Published it in October 2 years ago. It was #1 on Amazon for 9 days straight and as a bestseller. And then it stayed #1 in the real estate section as well for an extra couple more weeks past that. So it's called Creative Real Estate Investing, and you can get that on Amazon.
Now, in addition to this, I know that you're also, you engage and co-host some podcasts, at least one. Tell us a little bit about that and how folks can find
Sure.
that.
Yeah, I appreciate it. It's called Real Estate Power Play. We've actually had Sean on a couple of times, and we have to get Sean on again because we can go on and on. I mean, when it comes to the legal aspect, like when you're talking about the LLC stuff, setting that up, I was just at a seller note convention up in Nashville, and people are starting to talk. And I know somebody that paid $45,000 to set up a trust because of the Transparency Act. And there's so many different ways, and they're like, oh, we don't have to hold everything in the LLC. We're going to put it into our trust now. And I'm like, wait a minute, it's just crazy what's happening out there because of Transparency Act that's coming down the pipe here that we all have to register LLCs. But anyways, hopefully that answered your question. I kind of lost my train of thought, what your question was.
Yeah, no, your podcast. We got into your podcast, and you were talking about getting Sean on. It is interesting as you dive into the details, especially when you're talking about creative finance, the legal issues, the investing issues. Even the long form podcast in an hour is never enough to get through all of it.
Correct. I totally agree. It's so much. You have to be in it for years to kind of really, and I've seen people in it for a couple of years and they still don't know all the different creative stuff. And then as you kind of work through, you end up doing creative deals that is not even like terminology. You just kind of figure out how to kind of be making sure it's done correct. The big thing is just making sure that, you know, the consumer protection regulations that you guys follow. That's the number one thing. And there's a lot of them out there where a lot of people don't understand.
Yeah. Well, again, we really appreciate you being with us. And if you're watching the show, go to our YouTube channel. In the description, we've listed all of the links to how to find Mark, his website, his book, everything else. So if you're just getting introduced to the value that Mark adds, get on there, check it out. He's got a lot of awesome opportunities. We provided a link also to his Facebook group, which is, 120 something thousand members. You got a lot of folks there interested in seller finance.
Yeah. And anybody that's, because we're pushing this live now, if you guys are listening, make sure you also follow these gentlemen too, because you guys need to understand more about from the legal aspect of creative financing. I mean, there's so many different levels within creative financing. So make sure you guys follow your podcast as well.
Well, we appreciate that. So we wanted to get into, obviously there's more than 10 pitfalls to creative financing, but we wanted to kind of nail down what are some of the big pitfalls that we see. And Sean and I have constructed a list of what we think are the top 10, but a little bit of a caveat to this for the listeners. You know, Sean and I are lawyers. We're by no means, you know, the guru investors in the space. We're the lawyers that have the fire alarm and say, okay, this is how we want to see this done to protect you. But there are, you know, pitfalls that folks like Mark's going to see that are very different than ours. So let's go through these. And Mark, you know, add what you see from the investor perspective as well, whether you agree or disagree with us on some of these things. So these are in no particular order, but number one, for us, a big pitfall is failure to make the necessary subject to disclosures to the seller in the transaction. So oftentimes in these sub 2 deals, creative finance deals, the buyer's the investor, right? And the seller's just somebody trying to sell their home. How important, you know, in your practice, Mark, is the disclosure to the seller? Because in a lot of times, almost always, I shouldn't say almost always, I'm sure you're buying and selling, but oftentimes I'll bet you're the buyer in the deal like this.
Majority of the time I am the buyer, trying to, but yes, it's 100%. Because I mean, I've learned by mistakes over the years. I've been pulled into, because, you know, you're going into a state and you're using the wrong type of documents in a wrong state, and, you know, things can kind of go sideways because you use the wrong documents. So you need to make sure that all your disclosures are done correctly. And one of the biggest problems, you said it in the beginning, there's not enough attorneys out there. And what happened was I could not find an attorney in the state to understand creative financing. And I used some documents and I went into that state, and sure enough, the people in the property stopped paying. I had to go through the process, and because of the wrong documents and everything wasn't done correctly for creative financing, it ended up costing me $47,000. So it is extremely, extremely critical that you understand making sure. The good thing is there is starting to be more and more people that are coming into the creative financing world of attorneys, but even some attorneys don't even understand really what takes place, because then they go, an attorney may know what they're talking about, then they go in front of the judge, and then sometimes the judge don't understand it. So that it's very important that the attorneys, the lawyers, educate the judges on it, because it's you can read one thing and then it can be interpreted as something different, but the disclosures will protect you as best as possible. But you also need to make sure that disclosures are correct, because, like, again, I went into a state and I did one deal in that state, and there was the wrong disclosures, and it came back and bit me hard.
Now, Sean and I have talked about this issue, and that is, Sean, I lost my train of thought. Mark brought up a point that you always, the wrap transaction. So,
Right.
you know, one of the things, and I think lawyers and forms can sometimes add value, is, you know, the YouTube gurus in the space like to put a flashy new term to it, and it gets before a judge, and like you said, the judge is like, I don't even know what this is. And when I don't know what something is, that's a problem. That sounds fishy to me. But, you know, Mark, you mentioned in your introduction, you've been doing these kind of things for a long time. In the past, you know, it's had common names like the wrap, or you mentioned sandwich transaction. Sean talks about this all the time. Judges know what a wrap transaction is. And when you can present it to them and know how to present it and know what to call it, it sounds something to them far less risky or innovative or something like that.
100%. I always tell people when you're talking to a realtor or you're talking to anybody, you really, I hate to say this word, and it's but you really have to dumb it down, if that makes sense. You have to make it simple, because things, when you try talking to people, if they don't understand it and their head spins, they're just gonna be like, oh no, wait a second, kind of walk away. One of the things that I've kind of learned over the years is if you can't find an attorney in a certain state that understands creative, start looking at loan servicing companies. A lot of times they will have some connections, especially some of the larger ones. That's kind of where I've been kind of learning a lot of times, where if I can't find somebody in those states, I'll reach out to a loan servicing company. And a lot of times they have a lot of these disclosures already in place, but still, you still want an attorney to represent you and make sure that everything's correct.
So for our number two, and so number one was talking about disclosures to the sellers. Our number two deals with not giving the proper disclosures to the buyer. And I will tell you, in my practice, that is the biggest breach or violation that I see over and over again. And I've seen it wreck multiple transactions. In fact, on our little video intro, I have a little statement like, well, maybe the buyer doesn't know it's a subject to, and honestly, there are times, I'm even aware of closed transactions where the buyer's like, wait a minute, what are these other loans out there? And so number two for me is the buyer not being presented with disclosures. At what point in the transaction should a buyer be presented with, the information like, hey, this is going to be, subject to some existing loans? Should that be in the marketing? Should that be in the, transaction paperwork? Should that be before closing? At what point should the buyer be brought in and be made aware of all this?
That should be immediately before you even start a contract. You should be upfront disclosing exactly how the transaction's working, and this is why it's working. It's helping you, because otherwise you can't go through your traditional lending. So there is this other option, but don't just be upfront. Explain the process to make sure that the buyer's educated and they know everything, because you don't a doing sales clause, that could, if they get a piece of mail in a mail that was the seller's information and they call up and, hey, what is this? You could end up triggering a doing sales clause. So you really need to make sure that everybody's on the same page. A lot of times what I like to do is I even like to videotape it or do Zoom and go over that stuff, so everybody is on the same page, so people can't get confused. Oh, I didn't understand what this paperwork was that I was signing. So if you have like on a Zoom, and I always recommend using a third party, somebody totally separate, like a title company attorney. Make sure that they're going through everything, so they're explaining everything in detail. But typically you always want to disclose it before you even start a contract up front, and in your contract you should disclose it in your contract too as well, what is going on in the type of transaction. That's my opinion.
Well, and funny you should mention that. As far as having an attorney involved, I think a lot of times investors get leery because of what we talked about before, attorneys not fully understanding it. But I think that there's certain types of transactions, especially with buyers who are, a consumer buyer going to live in the property. I think it's critical to try to connect them with an attorney and make sure that they're represented, throughout the process, so that, it makes you feel more comfortable as the seller selling creatively, that look, the buyers were represented by counsel. They were informed. Everything was on the up and up and smooth, and they can't come back and say, oh, I was somehow deceived or tricked or whatever, because, hopefully the attorney was doing their job and giving the right, guidance and advice.
I totally agree.
So our number three pitfall with seller financing or creative financing is the failure to properly structure the purchase price and its components. Now, this one sounds mysteriously kind of basic, and most might wonder, well, how do you screw that up other than just negligently not filling it in at all? Of course, that could happen, but I'm not sure that that's usually the problem. And I know Sean's dealt with this a lot. So Sean, before we turn it over to Mark, why don't you give context and how you've seen this be a serious problem, and then we can shoot it over to Mark.
Yeah, it's primarily for subject to transactions where you have a static purchase price. We'll just say $1 million to make the numbers work. And then you put in there that the first position loan taken subject to is going to be 500,000. The seller's going to carry 250 and cash at close is 250, right? And then lo and behold, you get the payoff on the first. Well, the payoff's now 400,000. Well, you don't have anything in there saying that the purchase price adjusts downward in that scenario. It's a locked in purchase price. So somewhere there's an extra $100,000 coming to the table. And that is a scenario that I've seen play out over and over and over again. So what are your thoughts on how to, do you see that with, the folks that you coach and work with, and, what are the solutions?
Typically I've seen it go the other direction. That's where I usually see it.
Yeah. Okay.
But yes, you're correct. I always actually had somebody reach out to me, and it was a newbie investor that was purchasing it from a wholesaler that was a subject to, and they use a transactional coordinator, and the investor had no clue about looking at and what to do, and they went with the transactional coordinator, but they didn't have the payoff because during COVID these people fell behind, and so there's extra payments added on to the rears. So it's very, very critical for me, at least, to make sure you have all the payoff all the payoff numbers up front, and do a title research. That's how I usually get around it. But Sean, I'm going to definitely throw this back over to you, because I'm sure you have some legal language in there that you kind of recommend on that. But from an investor point of view, that's how I handle it. You want to make sure you, as the investor, that you're reviewing these documents yourself, not going off of a third party. If you have your own personal transaction coordinator and you feel confident in, that's perfectly fine. But I still recommend you should always look at that payoff from the lender, so then you make sure on your closing documents those numbers are matching up. But Sean, why don't you kind of talk a little bit about that?
Yeah. So basically, you can't have everything be static when you have an adjustable payoff number. So if you think that number is going to go up or down, you're going to have to find a way to structure the purchase price or have language in there that allows certain things to adjust. So for example, you can say that the purchase price will be the combined total of the payoff of the existing loan, the $250,000 second, and $250,000 cash at close. Well, in that case, then the purchase price is going to be fluid and adjustable, right? And so then it can go up and down. Or you say, well, the payoff is static, it's the same, and then for example, the seller financing will be the difference or between the purchase price minus the payoff minus the cash at close, and then the seller financing gets adjusted. But it just depends on what you negotiate with the seller as far as, what's going to adjust. I had one the other day where I thought that some other numbers were going to adjust and change, but the client came back and said, nope, I agreed that this is the purchase price. And then, I think the seller financing had to adjust to make up for any, difference in the numbers, upwards or downwards. But that was the purchase price. It was locked in. So you have to decide, okay, is the purchase price going to be locked in? Then you have to have language I always allow the escrow agent to fill in the final numbers and that on the settlement statement based upon a math equation of some sort. And those are your numbers. But you just have to figure out what gets adjusted. And then you can add in the magic language that allows for it to be adjusted. But if there's no language, like a standard purchase contract generally isn't going to have that language. You have to have something in there allowing escrow to adjust it and put it on the final closing statement or settlement statement based upon the language of the contract.
I like that. So what would happen in a situation where if the purchase price and the numbers were a little different and 2 years later something happens and you go through the court process? How is that looked at?
As long as it's in the contract, it's fine, because that's what the parties, contracted for, at least here in Arizona and Wisconsin, where we don't have tons of regulations. generally your contract's going to control. And so as long as the parties put it in there, then you're fine, and there's no issue there.
I think one of the other undiscussed topics that's related to this is obviously there's an importance in using the right form and thinking, having that option to be able to deal with the purchase price. Okay, so step one, you've gone and got a good creative finance attorney. They've thought through this and they've done that. Step two, in my opinion, is what often gets lost, which is it doesn't end there. You have to understand the form that you're using. I don't know how often you see this, Sean, but or Mark, that folks pay for the form and they just figure, you mentioned like a transaction coordinator. I can just hand it off, fill it out, and we're done. It's just plug and play and we're done. And no, these things require a thoughtful review and understanding of the document itself. The lawyer can only do so much in creating it. It relies on your ability to know how to use the tool, right?
No, 100%. The problem is a lot of people don't understand what they're doing. And that's why we want you guys out there helping, all of us out there trying to help promote and educate people on this, because we don't want the industry to be destroyed, because if things are not being done correctly, subject to could become illegal. And so we want to make sure you guys are out there informing. I see a lot of wholesalers trying to do these type of transactions and without any type of training or experience, and not relying on a professional to kind of help them through that process. So make sure, if you're listening and you're kind of new and you're kind of trying to figure it out, team up with somebody that knows what they're doing, or reach out to an attorney that can help you. Just make sure you have a professional by your side guiding you through the process, because again, they don't know how to read some of these documents and what they're looking for.
All right, so number 4 on our list of pitfalls for seller finance investing. This is somewhat similar to pitfall number 1 and 2 in that it is dealing with disclosures, but this one specifically is failure to provide a distressed seller with certain state law required disclosures. So now we're really talking about a distressed seller, and that has a meaning to it with regard to particular laws, and some states care about that. Other states may not have a law about that, but there are states, Colorado comes to mind, that do have specific requirements for distressed sellers. Mark, is that something you've run into? I know you have experience in different states, or run into having to deal with different types of disclosures in different states for a distressed seller.
Yeah, it is. You just need to make sure that you do your research within the state that you're doing business in and find out about the distressed sellers. A lot of times people don't know where to look. Just again, reach out to these gentlemen. They can refer you to somebody in the state if they're not doing business there. And a lot of times also find a title company. A lot of times they understand it and they've been through it, so they can kind of guide you to find the right person that can kind of help you out with that stuff. Again, I like to reach out to some loan servicing companies, because they have some of that too, to make sure. But if you do it the correct way and you're helping a distressed seller and you're doing the right thing, you'll be able to feel good about yourself as an investor. Like, I can't tell you how many times like I've helped somebody out that was facing foreclosure, gone in there, helped them out subject to, and then I did one not too long ago, and the seller called me up and was thanking me because her credit score was 804 and she could go off and buy another property. So just make sure you're always in constant communication because the other thing about subject to transactions, and I always tell people when you're talking to people up front about this, your buyer or seller, you have to think of it like this. It's a marriage. You're going to be in a commitment. It's a contract. So you're in a commitment for whatever term that you're doing, 5 years, 7 years, 10, 15. So you all need to be on the same page. How would you like talk to your spouse? You would all want to be disclosed and on the same page, communicating with each other. So treat your buyers and sellers the exact same way as you would treat your spouse, because it's a long-term relationship.
And I know this is a creative finance topic, but I will give a public service announcement out there to anyone in operating or investing, I should say, investing in real estate in Colorado and any other state that has a similar law. Keep in mind that the disclosures that you have to provide to a distressed seller, and a distressed seller is someone that's 30 days past due. It doesn't even have to be in foreclosure. So that's very important. The disclosures you have to provide aren't just applicable to subject to transactions. If you're going to go in and buy through, say, a cash purchase, not even wholesale or anything, you're just going to buy it as a long-term rental hold, and that seller is 31 days past due, you have to provide those disclosures and a 3-day right of rescission and have the magic language that the statutes require. The only buyers that don't have to provide that to a distressed seller is a buyer that's going to own or occupy. Anyone else has to provide those disclosures. So it's not even just in the creative space. Be sure to know if you're dealing with distressed sellers in Colorado or similar, there are other states that have similar laws, make sure that figure out if that seller's distressed, 31 days past due. If they are, make sure to provide those necessary disclosures.
All right. So number 5 on our list of pitfalls for the seller finance investor, failure to select the correct title company. Like law firms, in our estimation, title companies are very important. Sometimes they can't get out of the conventional box of doing things. What's been your experience in that regard, Mark?
Oh, 100%. There's enough networks out there now where you guys should be able to find a good title company that understands it. But it's critical. Make sure, like, if the buyer or seller, they want to use their own attorney or title company, whatever, make sure they understand the process, because if not, you guys get to the closing table and things go sideways because they don't understand the process of it. Just like some investors are, the buy and hold, they don't understand the creative financing process, if you will. So it's a given. You need to make sure that, and there's enough resources out there where you can just reach out through our networks, that we can kind of provide all these different title companies out there that be able to help you out. But it's a given, and have that person as part of your team as you go to.
Now, with social media, and especially what you've done, Mark, you've been able to build a significant network, but that hasn't always been the case. And so when you as an investor were like, well, to back up, these deals always happen quick, right? You hear about an opportunity. It's like, well, I want to move. But when you as an investor are approaching a new state, and you've done this a few times, there's got to be some sort of canvassing that happens where you're looking, okay, who am I going to use? The title company, the lawyers, understanding the demographics of the area. How did you approach all that when you were given the opportunity of kind of a new state to jump into?
I would reach out to somebody that I'm already doing business with in a different state. Like, say, for example, I would reach out to, hey, do you know anybody that's doing business in Colorado or West Virginia? Do you have any contacts? Most people will have some other contacts of people that they know. If not, hey, do you know somebody else? Reach out to, like, you all and see, hey, who's your contact? So that's the beauty of today's, with social media, not even social media. I mean, look at our phones. I mean, our phones have so much contact information in there. So contractors, but title companies, closing agents, attorneys, like we talked about earlier, trying to find attorneys helping out with our disclosure documents. I think that's probably one of the key components in today's environment, is making sure that you have somebody in the States, because, like I mentioned earlier, I got into a state where I didn't have the right contracts because I didn't have the right resources. So that can happen. So even myself, I'm an experienced investor, but I still put myself in his shoes because I couldn't find somebody. So you just kind of reach out. And now today it's a lot easier finding people to connect with.
It's not on our top 10 list, but we kind of keep coming back to this throughout. And I want to get your take on this. It almost seems to me that getting into creative finance, seller finance investing generally, maybe any other type of investing, a pitfall in and of itself is trying to do it without a network, without establishing a trusted group of people you can turn to and help you navigate things.
It's 100%. You can't go through this without having good contacts and getting into it. Unlike your traditional, like the vanilla, what we call, where people don't know, they're used to going through a realtor, looking on Zillow, trying to go that way. With the market that shifted so much nowadays, people are starting to become more learning more about it. Years ago, we all been here, like we've been through cycles in the real estate market. So you kind of go through the cycles, and we went over 10, 12 years with everything just kind of going upwards. When the market pulls back, that's when these type of creative strategies tend to come in. Everybody was doing the wholesaling on the price of locking it up and, flip now you have the wholesalers coming in doing the subject twos, the creative stuff. It was never around. Assignments and subject to world were never around until the last couple of years. And we all experienced investors are always the ones that stayed in the middle and took the deals down. So it's definitely changed a lot over the years, but you need to make sure you have experienced people, because if you don't know what you're doing, you can get over your head, you can get hurt very badly financially.
All right, good stuff. So moving to number 6, we don't have to spend a ton of time on this because I think we've probably beaten it to death. But number 6 on our list is failure to use the correct contract and forms. You've given us specific examples of the consequences of that. I think that one is one of these pitfalls that goes without saying. Everybody's like, okay, yes, we're not dumb. We know that that's the case. The problem I think we have, because the internet is so good, because it is such a good funnel of information, and it makes it easy for people to get information. I think people focus so heavily on finding whatever YouTube influencer that they love, who's got the package form list that they're going to spend, and they think they can get that done right. And they just go do that, and they think they've done it, and they forget that there's 50 different jurisdictions and laws, plus a federal government law that applies, and there's never one size form fits all, unless you're going to stay in one geographic area and you're never going to move out, right?
I totally agree on that one. Again, I'm a prime example. I went there, but the other problem is I see a lot of people coming into it and they don't want to spend an extra, $1,000 for having somebody help them out and review the correct documents, and they think, oh, but let me tell you, that $1,000 can be a lot cheaper than what can happen in the long run. But again, long as you're listening to like what you guys are putting out and listen to experts and follow what they're saying, you can do extremely well in this. But contracts are very, really important, especially like you're saying. I went into an area and used the wrong contracts and it came back. So anyways.
All right, 7. We're on to the number 7 pitfall. I don't know if this is as big of a pitfall with seller finance. We'll let you tell us, Mark. We know it's a pretty big pitfall in creative finance. And for the listener, we can kind of define maybe what we mean between the two of those. But failure to properly acquire and structure property insurance. We see this done wrong on the creative finance side of things quite a bit. But what do you see from the creative finance side and the seller finance side of that from an investor perspective? How important is the property insurance and getting that right?
It's extremely important. If you don't have it set up correctly and you transfer the deed out of the seller's name, but you don't change the insurance over and you have to do a claim, you could be good luck trying to get the insurance company to pay you out on that one. Sean, why don't you talk a little bit about that too?
Yeah, that's exactly right. A lot of people think, especially on the creative or the subject to side, okay, well, I'm making the monthly mortgage payment. The monthly mortgage payment has an amount for insurance. And so I'm good, I'm covered. Well, no, because the seller is named as the primary insured under that policy. And, insurance companies are great and they're important, but they don't like to pay claims. And they're going to look for any reason not to pay a claim. And one obvious reason would be that the primary insured no longer owns the property, and therefore they do not have an insurable interest in the property. I can't go and put insurance in my name on my neighbor's home because I don't have an insurable interest in my neighbor's property. And it's the same thing for a subject to transaction where the deed actually transfers to the buyer. In that case, the buyer needs to be the primary insured. So they need to either go get their separate policy and keep that on the side with them as the primary insured, or they need to get that policy, name the seller as an additional interest or an additional insured, name the lender as the mortgagee or loss payee, and then submit that to the mortgage company. And this gets back to competent people, right? You need to make sure that the insurance agent you're working with is competent and knows how to set it up that way and knows what to say if they're ever asked about, well, why is the seller listed here or there? And, how to properly communicate all the information to the mortgage company so that you can take your policy naming you, the buyer, as the primary insured and replace the seller's policy.
It's key. And then, I also seen this happen before where the seller sold the property and the buyer was never added to the policy and they had to do a claim. The seller received the check and never forwarded the funds on to the buyer. So you need to make sure that's done. So there's so many different areas. Like you said, it could be a huge pitfall if it's not set up correctly.
Well, and this reminds me, really just jumping back to our last pitfall, which we just jumped over kind of quick because we were talking about using the wrong contract and forms. One of the things that I think illustrates as part of that pitfall is the contract and forms section. So obviously you need to use the right contract, but oftentimes an appropriate seller finance or creative finance kind of package of documents is going to include way more than just the purchase contract, because as investors have been doing these deals longer, they realized, well, okay, I needed more than the purchase contract. I needed an assignment of insurance proceeds. I need powers of attorney to help me talk on behalf of this seller who's going to still be on this mortgage, so on and so forth. There's really kind of a library of forms that are hard to just kind of just at random think through that you're going to need without having done it, without having to, like you said, Mark, this is like being in a marriage with somebody. They don't go away, but they might go away. But you still have to deal with their name being on things if they do go away. So, properly handling that, as well as, insurance documents that assign insurance proceeds and things like that. A lot of these things really do go together. All right. So that is our number 7. Moving to number 8, our number 8 pitfall: failure to comply with the Dodd-Frank SAFE Act. Sean, why don't you go ahead and kind of describe what we mean by that? And Mark, we'll see what you think.
So this doesn't apply to the acquisition side. You can go and acquire seller financing all day long, and you're not going to have any problems because you're the buyer, you're the borrower. But it's on the disposition side. So if you're going to convey property via seller financing, whether that's you own it free and clear and you're going to finance the purchase price and be the lender, or you're going to take a subject to and convey it subject to, there are federal regulations, i.e. the Dodd-Frank and SAFE Acts, which basically put restrictions on both the number that you can do per 12 rolling 12 calendar months, as well as the loan terms, as well as your obligation to make sure and basically pre-qualify the buyer. And if you are going to exceed your requisite number, which I believe is 5 for every 12 in a 12-month period, then you have to go through a RMLO. Have you, I mean, honestly, I'm sure you have. Have you seen this violated quite a bit by investors in the marketplace?
You wouldn't believe it. And then you have the RESPA Act as well.
Yeah, right.
And what really blows me away is nobody's doing this. But years ago, it was key. When they're posting in the listing the property, they're supposed to be disclosing their APR. And they don't realize that. You know what I mean?
Right.
And so there's a lot of different acts out there. It's just, again, us trying to inform these people about all these different regulations. I mean, sometimes I scratch my head, is like, years ago, the regulators were always around, and like past 5 years, where are they? But knock on wood, we just make sure you guys are doing the right thing so you don't run into these issues, and just educate yourself on all these different, consumer protection regulations.
All right, good stuff. So jumping to number 9, the number 9 pitfall, I kind of gave away the goat earlier here, but failure to obtain an assignment of insurance proceeds and a limited power of attorney for subject to transactions. We've already talked about that, but these are forms beyond the forms. Forms that could you get a subject to a creative finance, seller finance transaction done without them? Sure, you could. Could you have a binding contract without those? You certainly could. Will it be easy to facilitate that contract after the fact? No, you're going to have lots of pain points without those. So it's how often do you see that though? I think you probably see it a lot, Mark. Folks just rushing forward with the purchase contract, not thinking through the after the fact, the end of the after the deal part.
Yeah, majority of the people don't use those disclosures. They just kind of push through, and they think, it's not going to happen to me. It's like, the speed limit's 55. I'm going to do about 65, that type of thing. And I see that, especially with new investors, until it happens to them, then they start putting those disclosures in place. They don't want to listen to us up front. But that's kind of usually how I usually see these type of other secondary disclosure documents.
All right. And our number 10, Sean, I'll let you give some context to this, but not understanding the best transaction structure for each loan type. What do we mean by that, Sean?
Yeah. So what I mean by that is, out in the marketplace, you have basically 4 primary loan types. In Arizona, we primarily have 3, but I'll lay out a 4th. So the first one is your Fannie Mae, Freddie Mac loan. The second one is your VA loan. Next one is your FHA loan. And then the 4th is your community bank, who holds their own paper. And so each of those, in my view, has some nuances that you need to be aware of and understand. So for example, VA loans, agreements for sale work on VA loans, but I would not wrap a VA loan. I would do a land contract or contract for deed or agreement for sale with a VA loan. Fannie Mae, Freddie Mac wraps are fine. They work. Community bank, not sure, depending on the bank, that I would do either of those. I might try for an assumption on a community bank. So, those are the different kind of scenarios that you have to be aware of and know, like, okay, if this is the type of loan, this is what I need to be thinking about and doing and how I need to be structuring the transaction.
That's a given. And it also depends on really what the seller's needs are as well, to make sure their situation. But 100%, you need to, I call it a tool belt, depending on what the situation is, depending on what type of loan it is, and depending on what the seller's needs are. I'm explaining from an investor's point of view. It's great, Sean, you talked about it from the legal side of it, but from an investor, what we look at is, if they're not financial distress, I don't even bother crazy. So you kind of need to know a little bit more about that and have those situations. But same thing with community banks. You got to be very, very careful on some of those. I have a good friend of mine that owns a community bank, and what they're starting to see is they're starting to see some subject to defaults coming into play. So they're starting to pay attention to some of that stuff now. So, and they weren't paying attention to it. So like what Sean's saying, go ahead and reach out and see if they're open to an assumption. They're definitely available. So you don't know that until you start going through the process, because community banks, they're a lot easier to kind of negotiate with versus, Fannie Mae and Freddie Mac. They have certain guidelines that they have to follow.
So Mark, that is from the lawyer perspective, our top 10. If you've got, with just the little bit of time we have left, if you've got a newbie coming in and they say, Mark, I know you've done a lot of these. I really want to think about this. Obviously, you're going to walk them through a lot of different things, but what in your mind is the biggest pitfall out there from an investor's perspective for folks trying to get into seller finance?
Yeah, I think I touched on it earlier, is subject to was never designed to do assignments. It was never designed really to do wholesaling. It's really come on in the last couple of years. And these people think like, hey, I'm just going to assign this to my end buyer. They're looking for that large deposit. They're looking for that 20, 30, 40, $50,000. They're not even qualifying the end buyer, especially if it's a homestead buyer. And I think that is going to be one of the concerns. Like, if we don't get our hands around it and educate people, it could destroy our industry. I remember back in 2003 to 5, people went to jail over that stuff. They were just taking those people large down payments of the consumers, put them in the property, and then they're defaulting. I think that is probably the one big thing. out there. And, these wholesalers, you guys, if you learn it the right way and be the investor, you can make so much more money staying in the deal. Just team up with somebody that has the experience that can hold your hand through the process. That's how most of us learn that process, is somebody taught us. I became a bird dog out there for somebody else. They had the capital to back them. So if the buyer defaults on it, that's the biggest thing, where the wholesalers, they don't have the capital, and that if the buyer defaults, that, oh shoot, what do I do? And that's why they're doing assignments. You can make so much more money making money in the front end if you're negotiating correctly. You got to make sure you negotiate, make money in the cash flow, and you can make money in the back end. You guys are leaving $50, $100, $150,000 on the table, not staying in these deals over terms. You're just out there trying to do that $10, $15, $20,000, $30,000 assignment fee. Yes, it's great, but then you're out there grinding it to get your next deal, where if you do it the right way, you can do 5-7 deals a year and be comfortable. But again, if you're out there and you're wholesaling and you get into a situation where your end buyer defaults, just don't send it off to the buyer and let them kind of sink the ship. Roll up your sleeves and do whatever it takes to kind of help everybody out in that situation. So I think that is probably, for me, from our point of view, from us investors that have been into it for so long, is what we're really concerned about, because what we see in the last couple of years of really what's happening with assignments in a subject to world.
All right. Well, Mark, it's been an awesome discussion. Thanks so much for being with us today. Tell our listeners how they can connect with you.
Sure. The easiest way they can connect to me is go check out my website, Mark, M-A-R-K, the minus sign on the keyboard, Monroe, MONROE.com. And from there, it has all my links to all my social media, resources. And if anybody has any questions, feel free to reach out. I'll be more than happy to jump on a phone call. It's all about helping each other out, networking, and make sure things, we're all helping each other in the community. It's such a small community. Let's all take care of each other.
Yeah, for sure. And for those that are watching, go to YouTube. In the description, we've got all the links to find Mark. Get into his seller finance group on Facebook. Really good resource. Mark, it was awesome. Let's do this again soon.
Yeah, and I can't thank you guys enough for doing this and putting this content out there. It's really helpful for everybody. Thank you, guys.
Yeah, no, we're happy to do it. We'll see you next time, Mark. Thanks for being with us.
Take care, guys.
All
Be
right.
well. Bye-bye.
With that, everybody, that is our show. Make sure to join us today at 2 p.m. for The Collective. Stay safe, and we'll see you next week.
Have a good day, everyone.